So, hello everyone. This is Legal Lindsay, and we're going to discuss warranty against hidden defects of or encumbrances upon the thing sold. This is part of the RFBT series. So, to give you an overview, the concept of warranty plays a significant role in ensuring fair and balanced transactions. One specific type of warranty that safeguards buyers is the warranty against hidden defects of or encumbrances upon the thing sold. This warranty protects buyers from unknowingly purchasing goods with concealed flaws or burdens that significantly impact their usability or value. Let's get started. So, what are the requisites for enforcement of vendor's liability against hidden defects? Ano yung mga requirements para ma-enforce yung liability ni vendor against hidden defects? Number one, existence of defect. The defect must exist at the time of sale. Number two, hidden defect. The defect must be hidden, not visible to a non-expert buyer. And experts are considered to identify defects related to their trade or profession. So, let's give an example. For example, you bought a car from a dealer, and shortly after driving it, you discover a major engine problem that the dealer did not disclose. So, this engine problem is a hidden defect, and the dealer may be liable for it. So, what are the requisites in order to enforce the vendor's liability? The defect, which is the car's, when yung problem do sa car engine, it must exist at the time of sale. It must exist when you buy the car, not develop later. So, kailangan nag-exist siya at the time of sale, okay? Number two, hidden defect. The defect must be hidden and can't be seen during a normal inspection. So, for example, you're not an expert buyer. You would not have known about it, okay? And it is hidden. So, the vendor may be liable. However, experts are expected to identify defects related to their trade or profession. However, kung uh, expert ka, let's say you're a mechanic, and because of your trade or profession, you should have known about it. You should have known the problem. The dealer may not be liable. So those were the two requisites. Next, I unfit for use. The defect must render the item unfit for its intended use and significantly diminish its fitness for intended use. Buyer would not have purchased it or paid less if they knew about the defect. So let's use the initial example we have earlier, the engine problem of the car. So that defect makes the car unusable for its intended purpose. You, as the buyer, would not have bought the car or would have paid less if you knew about the defect. Okay? For timely action, legal action must be taken within the prescribed period, 6 months for non-animal goods, 40 days for animals. So you, as the buyer, you must take legal action within 6 months. What when it comes to non-animals, such as the car, that applies to the example we had earlier. Pero kung in case of animals, within 40 days dapat in order to claim your rights. Number five, no waiver of warranty. Buyer must not have waived the warranty against hidden defects. So, you as the buyer did not explicitly agree to waive any warranty protection against the hidden defects. Okay. So, let's recall, ano ba yung mga requisites in order to enforce the liability of the vendor against hidden defects? Number one, dapat yung defect nag-exist at the time of sale. Number two, the defect must be hidden. Tsaka hindi ka dapat expert. Kung expert ka na because of your trade or profession, alam mo pala dapat yun, a vendor will not be liable. The defect must render the item unfit for its intended use. Number four, timely action. The legal action must be taken within the prescribed period, and there is no waiver of warranty. Now let's move on to the implied warranty of fitness for a particular purpose. So let's give the definition. Seller guarantees goods are fit for a specific purpose known to seller and relied upon by buyer. So when it comes to this definition, we can notice two requirements: the seller's knowledge and the buyer's reliance. Let's give an example to further explain this. For example, you're an aspiring race car driver and you're looking for a car to get started in local amateur competitions. You come across a seemingly great deal of sports car and you approach the seller. During your conversation, you made it clear that you intend to use the car for racing. You even asked the seller about its racing capabilities and modification. And the seller assures you that the car is perfect for racing and has been well maintained. So the first requirement has been met. You clearly told the seller about your intention and the specific purpose of the car. And trusting the seller's expertise, which is the second requirement, you bought the car. You relied on the seller's expertise. However, in your first race, the engine fails spectacularly, causing significant damage. This is where the implied warranty of fitness for a particular purpose kicks in. Okay? Since na-meet niya yung two requirements, sinabihan mo talaga si seller, alam ni seller yung specific purpose of the goods, and you relied sa expertise ni seller, the seller will be liable when it comes to the breach of implied warranty of fitness for a particular purpose. May exceptions. When it comes to patent or trade name, no warranty, wala siyang warranty unless otherwise agreed. Why? Bakit ganon? Because the buyer relies on the brand reputation, not seller's judgment. So for example, you bought a sports car para sa gagamitin nyo ang pang-racing. Kaso, bumili ka, ang pinagbasehan mo ay yung brand reputation. Kasi, yung brand is well known as a particular choice among racers. So, you relied on the brand reputation, hindi sa judgment or expertise ni seller. So, unless otherwise agreed, there is no warranty. Okay? When it comes to trade usage, implied warranty may arise from established customs or practices in the industry. So, for example, you bought a tool at a hardware store. So you tell the salesperson you need it for a specific task like cutting through a thick metal pipe. So yun yung specific task na kailangan gawin for that tool. And normally you'd expect the tool to be suitable for that task, right? That's the implied warranty of fitness for a particular purpose. Now imagine there's a specific type of tool everyone in the metalworking industry uses for this exact job. And this tool might not be the most obvious choice for someone who doesn't know the industry. Syempre, hindi mo naman alam talaga. Ganun. But because of the established custom among metal workers, an implied warranty exists that the tool is fit for cutting thick metal pipes. This warranty applies even if you did not explicitly mention the industry practice. Okay? So that's the trade usage. Here naman sa implied warranty of merchantable quality, the seller guarantees goods are fit for their general purpose regardless of buyer's specific needs. So, iba siya sa kanina na implied warranty of fitness for a particular purpose. Dito naman, general purpose lang. For example, yung katulad sa kanina, yung car, ang specific purpose niya ay pang-drive. Okay? Ganon. So, key features, general purpose, goods must be fit for the ordinary use. Saan ba talaga ordinary use na ginagamit yung car? Di ba pang drive? Ganon. So, yun yung general purpose. and buyer's purpose not relevant. The warranty applies even if the goods don't meet the buyer's specific needs. And it applies to sellers who deal in goods of that description. So let's give another example aside from car. Siguro yung sneakers or sapatos. Imagine you're buying a new pair of sneakers. You expect them to be fit for the general purpose of sneakers, which is walking and running. This expectation is automatically attached to the purchase, even if the seller did not explicitly promise it. That's the implied warranty of merchantable quality. Key features niya, yung goods are fit for the general purpose of the thing. This means that the sneakers should be suitable for normal walking and running. They should not fall apart after a few uses or have major design flaws that make them uncomfortable or impractical for their intended purpose. Number two, not necessarily for the purpose of the buyer. Even if you have a specific purpose in mind, like using them for professional athletics, the implied warranty only guarantees their fit for the general purpose, which is yun nga, para saan ba talaga yung ordinary use ng sapatos, di ba? Para makapaglakad ka, running, something like that. And present when goods are bought by description from a seller who deals in goods of such description. So this means that the warranty applies when you buy sneakers from a store that regularly sells them, okay? Not just a random garage sale. So the seller is considered a merchant of sneakers and therefore expected to provide goods that meet the general purpose or general standards of merchantability for that type of product. That's the implied warranty of merchantable quality. So implied warranty of merchantability in sales where a sample is provided, the seller guarantees the bulk goods will be free of hidden defects that would render them unmerchantable. These defects would be apparent upon a reasonable examination of the sample. Imagine you're buying a batch of apples from a farmer's market. You only uh, you're only allowed to examine a few sample apples from the top of the crate. And the seller is a well-known apple grower in the area and you trust their expertise. So here's how the implied warranty of merchantability applies in this scenario. The seller is dealer in apples, meaning they regularly sell them and are considered experts in their quality. You are buying the apples by sample, relying on the few you examine to represent the entire batch. So even though you did not expect every apple, an implied warranty exists that the entire batch will be free from defects that would make them unmerchantable. So these defects would not be apparent by just looking at the sample apples. So that's implied warranty of merchantability. Ano yung responsibility for hidden defects? As a general rule, the vendor is responsible for any hidden defects even if he is not aware. Kahit hindi alam ni vendor, liable siya sa hidden defects. However, there's an exception to the rule. The vendor can avoid liability if there's a clear agreement exempting the vendor from liability and the vendor was unaware of the defect. Pwedeng ma-apply dito yung waiver na pinag-usapan natin kanina sa requisites. Yun. So, if may stipulation na hindi magiging liable si vendor sa hidden defects na hindi niya naman alam. So, hindi siya magiging liable. Remedies of vendee in case of breach. Ano yung mga magiging remedies ni vendee, ni buyer, kapag na-breach yung warranty? Ano yung mga pwede niyang gawin? Una, action rehibitoria, withdrawing from the contract or rescission with damages. And number two, action quantum minoris, demanding a proportionate reduction in the price with damages. Let's say, for example, you bought a phone. Tapos, meron siyang hidden defect. Nakita mo, na-discover mo na may hidden defect pala. Sa action redhibitoria, you may return the phone and the seller gives you back your money as if the sale never happened. You can also claim damages for any additional losses you suffered due to the defective phone, such as repair costs or inconvenience. When it comes to action quanti minoris, yung reduction ng price lang, for pwedeng instead of returning the phone, you decided to keep it but demand a reduction in the price to reflect its true value in its defective state. You can still claim damages for any additional losses you suffered. So those are the two remedies that the vendee can choose from, yung action redhibitoria or action quanti minoris, rescission or reduction of price. What are the rules in case of loss of the thing with hidden defects? Yung thing nyo, yung thing na nabili mo na may hidden defect ay nawala. Ano mangyayari? If nawala siya dahil dun sa defect, yung defect yung dahilan kung bakit siya nawala, at yung vendor ay aware, he shall be obliged to return the full purchase price, reimburse any expenses you incurred related to the purchase, and pay you additional damages for the loss and inconvenience. However, what if the vendor is not aware? He he shall be obliged to return the purchase price pa rin, reimburse your purchase expenses, and pay interest thereon. Walang damages. Paano naman kung yung defective thing ay nawala hindi dahil sa defect, kundi dahil sa fortuitous event or dahil sa kasalanan ni vendee? If aware si vendor, he shall be obliged to return the price paid less the value of the thing at the time of loss plus damages. However, if the vendor is not aware, yung ano lang, i-return niya lang yung price paid less the return the price paid less the value of the thing at the time of loss. Walang kasamang damages. Okay? So, parang ang naging conclusion dito, if the thing was lost due to something unrelated to the defect or the fault of the vendee itself, the vendor's responsibility is further reduced. So, they only owe you the difference between the purchase price and the thing's value at the time of loss, plus damages if aware si vendor. So that's it for the warranties against hidden defects. And up next, we're going to discuss rules in sale of animals with defects or disease. Okay? See you and God bless. I'm rooting for you guys.